Good afternoon, distinguished panelists and participants, ladies and gentlemen across the region. Welcome to the 4th International High-Level Online Workshop with the topic, the current development in the South China Sea toward regional peace and security ASEAN perspective. My name is CSEAS. I will be moderating of the workshop, probably about 2.5 hours. Workshops organized by for Southeast ASEAN Studies. Ladies and gentlemen, as we know, South China Sea conflict should get full attention, especially from the ASEAN as the regional association which promote peaceful and prosperous in the region. The Center for Southeast ASEAN Studies, Indonesia, is one of the research center in Indonesia that really concerned to the development of the South China Sea issues and would like to contribute to find the solution in the South China Sea dispute settlement through 4th high-level international workshop. The objective of the workshop, among others, are to find the ways to reduce tension between the claimants of the South China Sea and to strengthen unity among ASEAN member countries to resolve the dispute in the South China Sea. Now, please introduce the panelists in order of Rajaratnam Studies, Nanyang Technological University, Singapore. Welcome, Professor Bradford. And after the Professor Bradford, we would like to the topics will be announced later. And the second, the speaker is Professor Donald Rothwell, Professor of Law, Australian National University. Welcome, Professor Rothwell. And then Mr. Abdullah Zulkifli, Assistant Deputy for ASEAN Cooperation Coordination at Coordinating Ministry of Politics and Security, Republic of Indonesia. Welcome, Pak Abdullah. And the last panelist is Mr. Viramala Anjaya, Senior Research Fellow, CSEAS. Thank you to all panelists for coming to this event. I would like to inform that each panelist has approximately 15 minutes for presentation, and then we have distinguished guests and all participants have a question and answer session after that. Now moving to our session, please welcome Dr. John Frederick Bradford. Just for your information, Mr. Bradford holds a Master of Science in Strategic Studies from CSEAS and Bachelor of Arts from Cornell University. He retired from the U.S. Navy with the rank of Commander. The current development in South China Sea toward regional peace and security is the topic of Mr. Bradford. Please, time is yours.
Okay, thank you very much. Everyone see me and hear me? Yes, okay, I got a thumbs up. So, Selamat sore from Singapore, and thank you very much for having me here today. As it said, I'll take about 15 minutes to talk about this issue. You know, when I first looked at the topic, my eyes were drawn towards the word current. And I thought, okay, so we need to talk about what's current, what just happened, what's about to happen. And I do think that's an important conversation. I also think that when I look at who the other panelists are and all the other people that are attending this prestigious high-level meeting, I think there's a lot of people that can make a lot of comments on that. And so as the first speaker, while I don't want to shy away from that, I thought it might be most useful to give some framing tools to put the entire issue into perspective. And more specifically, when I talk about framing tools is, if you're going to solve a problem, first you need to understand what the objective is, what the source of the problem is, and what you want to accomplish. So when people say to me things like, John, how do we solve the South China Sea problem? I always say, well, what's the problem? Is your problem a matter of freedom of navigation? Is it a lack of access to resources? Is it an invasion of sovereignty? Is it the threat of conflict? Is it all of these things? Depending which problem you see, and most people that ask me this are really only worried about one of those problems, depending which problem they see depends on which problem they want to solve. So in the introduction just now, we were specifically mentioned the tensions in the South China Sea. Well, are tensions really the problem? I mean, tensions aren't good, but would we have all these meetings if all it was tensions? I think the real problem isn't the tensions, but it's the risk of conflict. Or it is perhaps the spilling over of the conflict into other areas. So what I'm going to do is what I think I'm going to do is so actually I mentioned there was a bit of an issue before. Could I finish my presentation in a minute? Could maybe we ask Dr. Rothwell to continue? Pick up where I am?
Yeah, sure.
Yep, sorry about that.
Sure.
I'll be back in just a minute.
Okay. So we would like to continue for the second.
Sorry, you're upset because I didn't manage to fix the room because they only got it 5 minutes ago.
He's like paint all over the floor. He's really
Okay. So we are going to to continue with Professor Rothwell. In the meantime, Mr. John Bedford has something to do. I just want to introduce Mr. Rothwell, that the topic is the role of international law in the South China Sea dispute. And Professor Rothwell is probably information. The background is he is with Australian National University since July 2006. His research include on law of the sea. Professor Rothwell also has co-author and edited 22 books, including most recently the Oxford Handbook of the Law of the Sea. So please welcome Professor Rothwell for your presentation.
Good afternoon, everyone, and it's a great pleasure to be joining you today from Canberra. My brief for this discussion is to really provide you with a sense of the international legal framework for a consideration of the South China Sea dispute. And so I will very much try to give you that sort of framework perspective. And hopefully there'll be an opportunity in the Q&A to look at some of these issues in a bit more detail. And of course, my first image shows you the International Court of Justice, or the Peace Palace in The Hague, which of course is where the International Court meets, but also where inevitably many of the deliberations that are hosted by the Permanent Court of Arbitration also take place. And so for international lawyers, The Hague and the International Court of Justice are critical aspects of the lens through which we see a range of issues. So these are the questions that I want to briefly touch upon in my presentation, and obviously my time is limited, so I'm going to talk about them as I said, at a fairly high level. I guess the first starting point is for us to always remember that the international legal framework for the South China Sea sits within the United Nations Charter. The United Nations Charter, of course, adopted in 1945 at the end of the Second World War, and it's really the global framework for post-World War II international peace and security, with some really critical key principles there that are applicable to the most developed states and the least developed states throughout the world. The prohibition on the use of force and the peaceful settlement of disputes are really key principles that sit within the United Nations Charter. We can have discussions as to how well they have been maintained throughout the life of the Charter, but they still remain incredibly important principles which the Secretary General of the United Nations seeks to constantly reinforce. And to that end, of course, the United Nations Security Council, operating under its mandate under Chapter 7 of the UN Charter, has an important role in terms of maintaining international peace and security. But the other point I want to emphasize at this early stage is that, of course, the United Nations Charter provided a framework through which international law would be a key guide, a key set of principles within which the post-World War II international order should be framed and should be maintained, and an emphasis there upon dispute settlement with the role of the International Court of Justice that I've mentioned, but also the role and the importance of international treaties as being a key guide for international cooperation between states on matters of common interest. And so that brings us then to the law of the sea, and the law of the sea is an outstanding example of how these treaties that have been negotiated and concluded within the framework of the United Nations system have really become dominant in the law of the sea since the end of World War II. First of all, with the 1958 Geneva Conventions, there were 4 Geneva Conventions concluded in 1958. They were the initial instruments to deal with law of the sea issues. And then in 1982, we had the United Nations Convention on the Law of the Sea. That convention's, of course, been in force now since 1994. It has 168 parties to it. And most importantly, throughout the South China Sea region, all of the major countries, all of the major littoral states are parties to the convention. And of course, we know that the United States is not a party to the convention, but the United States will often assert that they respect and uphold the provisions of the convention. Now, in addition to that treaty framework, of which the Convention on the Law of the Sea is the most important aspect, we also have what we call customary international law, which is an additional aspect of international law that we need to reflect upon. It's based upon what's called state practice, what states actually do in their day-to-day business, plus opinio juris, states believing that they have a legal obligation to undertake certain types of activities. And we look to customary international law as being important when we can identify significant and widespread state practice. So it's not just state practice amongst a few countries, but state practice amongst multiple countries that's really quite significant there. And I guess one of the reasons why there's an interesting interaction between the treaty law framework and customary international law is that there's an argument that aspects of the Law of the Sea Convention may well have evolved since the convention was negotiated and since it entered into force in 1994. And that's where the decisions of international courts and tribunals become relevant in terms of some of our deliberations and indeed some of our understandings in relation to these matters. So with that framework, emphasising the importance of the United Nations Charter and the Law of the Sea, let's look at some specific issues that exist within the South China Sea. Now, obviously, one of the critical issues is the whole question of the status of islands, rocks, and artificial islands. And there are all of these features that exist within the South China Sea. And of course, there are reefs, there are atolls, there are shoals. There's a whole multitude of maritime features. But one of the really important aspects of why that distinction is significant is that, of course, some of those features generate a territorial sea. Some of those features generate no territorial sea at all. And likewise, some of those features generate varying levels of maritime entitlements. So the key provision here is Article 121 of the Law of the Sea Convention, where it talks about an island being a naturally formed area of land surrounded by water and which is above water at high tide. And an island under Article 121 of the Convention generates the full suite of entitlements under international law. So let me give you an example of a very large island, and that's Singapore. Singapore generates clearly all of the entitlements consistently with Article 121 of the Convention. The only limitation upon Singapore's entitlements are, of course, the maritime boundaries that it's concluded with Malaysia and Indonesia because of the maritime domain within which Singapore is located. In distinction of islands, we have rocks. and rocks which cannot sustain human habitation or have an economic life of their own, rocks only generate a territorial sea. So rocks do not enjoy the much broader entitlements of an exclusive economic zone or a continental shelf. And clearly in the context of the South China Sea, those are really important distinctions because, as we know, we've had decisions in which there's been quite a bit said about some of these particular issues. So there have been decisions by international courts and tribunals. The Pedro Branca case involving Singapore and Malaysia is useful to think about from the perspective of sovereignty over some of these low tide elevations and features. But most importantly, the South China Sea decision, the arbitral decision in 2016 was really important in terms of trying to give us a better understanding in terms of some of these distinctions between islands and rocks, what feature can sustain a human habitation, and whether a rock can have an economic life of its own. And one of the precedents that's often pointed to, which is reflective of state practice, in other words, reflective of the way in which countries interpreted the Law of the Sea Convention, is the case of Rockall. Rockall is, as you can see on the slide there, on the left of the slide, a rock that sits off the English coastline, off the Scottish coastline to be precise, in the Irish Sea. The United Kingdom originally said that Rockall was an island, and then it eventually made a concession and said that Rockall was in fact a rock, and therefore it doesn't generate an exclusive economic zone or a continental shelf. Now, in the South China Sea Award from 2016, we had a very extensive analysis and consideration of the features in the South China Sea that were before the arbitral tribunal. It's really important to always recall that the tribunal did not make any finding of territorial sovereignty. So it said nothing at all about who actually is the territorial sovereign who owns these particular features, but it did have a lot to say about the way in which those relevant features should be interpreted for the purposes of Article 121 of the Convention. And most importantly, none of the relevant contested features were found to be islands for the purposes of Article 121. Therefore, none of those features generate a continental shelf or an exclusive economic zone. I think from an international law perspective, that's really helpful in terms of seeking to diffuse, seeking to limit some of the controversy about the entitlements of some of these features in the South China Sea. Another aspect that's been getting a lot of attention, of course, is artificial islands. What's their status in international law? Can states construct artificial islands? And if they can, what sort of control or jurisdiction can they exercise over them? And do artificial islands generate maritime zones? Well, these are some of the features of naturally formed islands, and I've to a degree gone through those in my earlier discussion. But what the Law of the Sea Convention says is that there are mechanisms for the recognition of the existence of the ability of states to construct artificial islands, but artificial islands are not natural islands. And as a result of that, an artificial island does not possess a territorial sea. It doesn't have an impact on the delimitation of a territorial sea, exclusive economic zone, or a continental shelf. Now, I guess one of the interesting technical questions here is there a distinction between the building of an artificial island and land reclamation? And we can perhaps have a discussion about that a little later. Now, another important aspect that's relevant in the context of the South China Sea is baselines, because the way in which states throughout the South China Sea, whether it's the Philippines, China, Indonesia, Thailand, Vietnam, seek to proclaim their maritime zones are from baselines. Now, the normal baseline is the low water mark. But in addition to the normal baseline, countries can draw what are called straight baselines. And that's provided for under Article 7 of the Law of the Sea Convention. But then once again, there's a number of technical issues that arise in terms of the way in which baselines are drawn from various different features. And that's become interesting in the context of archipelagic baselines. Now, of course, both Indonesia and the Philippines are archipelagic states. There's no question mark about that. There's very little debate about the legality or the legitimacy of the archipelagic baselines drawn by Indonesia and the Philippines. But one of the issues that did come up in the South China Sea arbitration was the ability of a continental state, the ability of a mainland state, if you like, to draw archipelagic baselines. And the tribunal in the South China Sea arbitration made it quite clear that the provisions under which archipelagic baselines can be drawn consistently with the law of the sea convention are very narrowly constrained, and really only a legitimate archipelagic state can draw archipelagic baselines. China is not an archipelagic state. It can therefore not draw any archipelagic baselines in the same way that Australia cannot draw archipelagic baselines because Australia is not an archipelagic state. Another issue which hasn't gained a lot of attention in the South China Sea, though certainly has gained some attention in Southeast Asia, is the question of maritime boundaries. And to that end, we always need to be mindful that maritime boundaries can be determined by agreement between states through diplomatic negotiations, through diplomatic processes, or indeed maritime boundaries can be determined by an international court or a tribunal. And a court or tribunal will inevitably apply what's called a delimitation methodology. And that's an approach that you can find in the Law of the Sea Convention in terms of the basic framework for that, and take a look at Articles 74 and 83 of the Convention. But the way in which international courts and tribunals have interpreted those approaches is through this delimitation methodology approach, which predominantly relies upon initially using an equidistance or a median line approach. And here's an example of the way in which the International Court of Justice approached this type of issue in the case of Nicaragua and Colombia involving the Caribbean islands and the Caribbean Sea from 2012. The reason why I find that case really interesting is that here you have a mainland state in the case of Nicaragua, but you've got a series of offshore islands which sit off the Nicaraguan coastline, and all of those islands are Colombian. So you can see some parallels in terms of how some maritime boundary issues could possibly resolve in the South China Sea, given that you've got legitimate mainland states. Even the Philippines could be seen as a mainland state for the purposes of this type of delimitation. And so this gives us a sense as to how a court or tribunal could seek to revolve around some of these questions. And so here's some thinking about how some of the South China Sea islands could possibly be subject to maritime boundary delimitation using some of those approaches. Navigational rights and freedoms. I'm sure you're all familiar with some of these key aspects: innocent passage in the territorial sea, transit passage in international straits, and archipelagic sea lanes passage within archipelagic waters. Important to make some distinctions between merchant ships and warships. But as we know, China has taken a particular position, and indeed some other countries take this position, that warships in particular must obtain permission or provide advance notification before passing through a territorial sea. That's not a widely held position, but it's certainly a position that China takes, and this is the Chinese declaration that it issued upon ratification of the convention. And then finally, to conclude, we also need to be mindful that international law provides us with a dispute resolution framework. I made some reference to that in my early comments. And of course, the South China Sea arbitration is an example of the utilisation of those dispute resolution frameworks. And of course, some states within the region, Indonesia, Singapore and Malaysia, have sought to utilise some of these mechanisms on maritime issues and also territorial issues. So there's examples within Southeast Asia and the South China Sea of states seeking to use these peaceful means for dispute settlement. So thank you, Chair. I look forward to discussion in due course.
Pak Setiawan, are you muted?
Thank you very much, Professor Rothwell, for addressing the topic, particularly from international law perspective. Now we are going back to John Frederick Bradford, who will be speaking to us on current development in South China Sea toward regional peace and security. Mr. Bradford, please, time is yours.
Yeah, thank you. And I'm sorry for the interruption. Can we go back to the second slide? Yeah, so as I was saying, one of the most useful things to do is to have a contextual framing to look at a problem and understand the very nature of the problem. And then that kind of both allow you to understand what you want to get in terms of a solution and the appropriate path or strategy to get there. So one of my favorite models that I would suggest is one that I call the STAG model. And that is to look at any maritime security problem or issue and evaluate what are the stakeholders, the threats, the awareness, and the governance involved. And if you take a look at those four things and you sort of map them out, then usually right after that, you have a much better idea of what the problem is. You have a better contextual understanding of what you would like to, as a policymaker or a researcher or military officer, or however you come at this maritime problem, what you would like to accomplish, and you can see where the opportunities may lie. So I'm going to go over each one of these, but on this slide very briefly, the stakeholders are who are involved with the issue or the location, and what are the stakes that are involved? Why do they care, and what do they want to get out of it? Next is threats. What are the forces? And that should says force of people, but it should say force or people. What are the forces or the people who want to undermine safety and security? Next is awareness. How well do we understand the situation? And then finally is governance. And governance is not just the existence of laws, but it's the accountability and the ability to enforce the laws. It's that all those things coming together. I'm not going to, now I list them this order: stakeholders, threats, awareness, and governance, because it's easy to remember them in that order because it makes the word STAG. But each time it makes a little sense to go at it from another, maybe in a different order. So next slide, please. So first, governance in the South China Sea. Professor Rothwell has already talked to us a lot about the laws which are applicable. But, you know, as I mentioned, governance is more than just international and domestic law, but it's the ability to enforce that. And it's the idea that all parties, whether they be states or non-state or sub-state actors, have to follow the same laws. And in the South China Sea, one of the issues that we're looking at is that governance is generally weak. And it's weak for several reasons. For one reason, it's weak because there's a disagreement over which laws apply, where they apply geographically, and how they should be interpreted. Now, we've already heard a little bit about that in today's meeting, but this comes down to boundaries disputes, different countries or different individuals having different opinions or assessments of which laws they are obliged to follow, and then interpretation of those laws. And those interpretations may be found in formal documentation, such as ratification notes or domestic court cases, but they can be much more informal. They can be about these norms of behavior. And so the fact that the states disagree over the laws, and the fact that many of the states don't have strong sets of laws or have confusing sets of laws is a problem with governance. Also, there's limited law enforcement capacity. Of all of the states around the South China Sea, none, including China, have sufficient law enforcement capacity to enforce all of the laws that they believe should be enforced. And then finally, state, non-state, and sub-state actors all disregard or selectively enforce international and national law. This goes back to the same point as before, but it's important to understand that it's not just a conflict between states. It's not just that states disagree about how international law should be applied or disagree over which territories are theirs or which territories different rights and responsibilities should apply to. But you have a number of non-state actors, which include environmental groups or activist groups and private corporations that will choose to exploit weak governments in different ways. And then even within the states, you may not have a strong unity of national government. So a particular military unit or a particular Coast Guard unit, a Ministry of Fisheries may make its own interpretations. Next slide, please. So stakeholders, I've already previewed some of this, but one of the issues in the South China Sea is there are just so many stakeholders and their interests are so different. And those interests often clash. So generally speaking, when people talk about, quote, the Southeast Asia or the South China Sea problem, they tend to be talking about the regional states. These regional states, what are their interests? There's sovereignty, there's national legitimacy, there's the safety of their citizens when they use those waters, there's the ability to control the resources which are developed in those waters, especially important for the generation of national wealth as well as tax revenue for the state itself. And then in some cases, domestic connectivity. The best and most clear example of that is Malaysia. But they're not the only example of a state which has a very strong interest in the South China Sea as a source of domestic connectivity. So that's the regional states. You have the extra-regional states. Most famously and most actively, I would say, was the United States, but also Australia, Japan, India, increasingly the European Union and others. And what are their interests? They're very interested in the rule of law because it sets a precedent that may be important elsewhere or a precedent which may affect their military or commercial shipping. They're interested in freedom of navigation because, as we know, about half of the world's commerce transits through the South China Sea, and that is commerce which is directly applicable to the extra-regional states. And they also worry about the balance of power or military access. And I think here I'd like to just make the point that I often get, as a former naval officer, I often get the question, who controls, from a military standpoint, the South China Sea? And I think the answer is, right now, no one. Everyone has free access. Sea control is something which is gained once the fighting starts. And the better question is, once the fighting started, who would be able to gain control or, better yet, deny access to others very quickly? And so I think there's an issue there, because if you believe there's a military competition which goes beyond the South China Sea, which I think both China and the United States do see right now, then this could be a sort of battleground, and therefore you're jockeying for military position. I mentioned earlier militaries and law enforcement. I mean, in an ideal situation, military and law enforcement's motives are exactly the same as the national government's. But we all know, as a practical matter, that's not always the case. These agencies may be competing with one another or with other agencies for government resources, and they may have their own corrupt elements, which may also create different vested interests in the South China Sea. Local governments are important. Again, they're worried about the local safety and governance of their coastal communities, and they may have a different perspective on what's the proper policy priorities should be to the national government. I've mentioned already the shipping community and how important that is to the South China Sea. Right now, their interests are being met, but they're very concerned that anything could happen that would obstruct transit in the future. Petroleum and resource extractors, their goal would be to have safe, interrupted operations. The fishing operators, in this case, there's increased competition over dwindling stocks. So they're fighting with each other, right? And so they're entering into places that maybe they shouldn't go, or places where they believe they should go, but they know they're going to create conflict with others. And with the dwindling fish stocks, this is only going to become worse. I think we're facing an impending disaster in the South China Sea in terms of a collapse of the fish stocks. Tourism, mostly concerned with safety and tourism infrastructure, environmental protection, increasing amount of environmental movements. So sending boats even to the Spratly Islands to conserve corals and other issues. Scientific research, civil society and activism, often linked to nationalism, but not always. They can be linked to other things. And so, I could take a whole hour just to go on about all these different competing interests, but they're all there and they're all different. Next slide, please. So threats. Again, I think the South China Sea as a maritime security problem, one of the reasons it's so complex is because there are so many different threats and there are different layers. So we all think about the coastal state competition, and by coastal states, I mean all of the bordering states, including China, competing over access to resources and national territory and sovereign control. But you have great power rivalry we've talked about. This brings the ex-regional powers, and their conflict is already, in terms of tensions, a threat, but could boil up into a much greater threat. IUU fishing is another threat. Poor governance and motivation by the fishing units creates this. Natural disasters. So the South China Sea, as we all know, is a very dangerous place, especially when typhoons blow across the northern stretches across the Philippines and into Vietnam. Safety of navigation and overflight. This both includes the possibility of ship collisions. But I also like to point out here that not in the South China Sea exactly, but in waters near the South China Sea, the biggest maritime crises that we've encountered in the last decade have been air crashes. And thankfully, we haven't had one in the South China Sea. But as you all know, we've had several of those in Indonesian waters, for example, not far away. And there's no reason to think that this couldn't be an issue in the South China Sea. Especially where both airline and surface traffic is not as tightly regulated as it could be. Piracy and sea robbery. This is only an issue currently right in the edges. There's been some cases in the last decade around Malaysia's Pulau Tioman, some leaking out from the Sulu Sea into around Palawan area. But when you can see that the South China Sea is ringed on many sides with high cases of robbery and sea piracy, it is again a threat in the South China Sea, and then smuggling. And so the reason I point this out is all of these problems are interlinked and they're reinforcing to one another. So you have to say, what is the South China Sea problem? You have to ask what the threat is. And if you're most worried about coastal state competition, it's very difficult to divide that from great power rivalry. And many of these lower order threats are actually more immediate threats to the health and welfare of the people in the region. But they're very difficult to address properly without getting that state-to-state competition. Next slide, please. So awareness, I would say here in the South China Sea, there's a general shortfall, but it's improving. Awareness takes a lot of different forms. It's really just understanding the situation. A lot of that can be sort of technical surveillance using aircraft to patrol and satellites. But can also just be, is there good contact and discussions between the authorities and fishermen or seafarers or other users of the waters? And in this case, relative to places around Japan or around Europe or around the United States, there really is a lack of understanding of what's going on. So even like in the Whitsun Reef incident, I'll use that as an example earlier this year, the standoff and the presence of so many Chinese maritime militia vessels. People on the water that are sailing and fishing around Whitsun Reef and the Union Banks clearly know about this, right? But the question is, do the national governments know about it? And I think the answer is generally yes, but they don't have great data. But does it go beyond sort of a national maritime center? Well, in the Whitsun Reef case, the reason I'm talking about it is essentially the Filipino government started publishing the data that they had in their information center, and then the Vietnamese government was forced to respond, and then international organizations like the American AMTI and some civilian satellite folks kind of converged on it and did more research, and now we understand the situation much better. But for a long time, it went unknown to most people except for some specialists. But even things like STS, sea to sea transfers between illegal petroleum shipments or IUU fishing goes unknown because of its small stage and the lack of information. And then it's a matter of not only getting the information, but it's a matter of properly storing it, processing it, connecting analysis and distributing it, and getting the right decisions, the decision makers to make the proper decisions. And it's also a matter that we generally have a lack of sharing. People may have pride or competition over the information to not want to share it, or generally even when people do want to share it and they've checked sort of their pride or other issues aside, poor management prevents good sharing. Now, I want to say here that in comparison to much of the world, the information awareness is not so great, but it's improving rapidly. It's improving in the state's abilities to collect information, both by technical means and from humans. And as you can see in the rapidly improving maritime centers around the region, ability to process that data and use it is in the last 10 years has gone so far. I think that's particularly true in Indonesia's case. Next slide. And so you bring these things together, and what does this STAG analysis reveal? It reveals that we have weak governance, and this creates opportunities for states, sub-states, and non-state actors to all act in their immediate self-interest at the expense of others. Because the law does not apply equally to all, or if people can get away with breaking the law, they take advantage of weak governance to help themselves. And when I say people, I would say that is state, sub-state, and non-state actors. The lack of awareness is a major barrier towards improving governance and understanding the situation. So the lack of information hurts us in two ways. One, it makes governance worse, but two, it makes people who want to improve governance or otherwise tackle the problem do so without a full understanding of what needs to be done. Next, the competition between the stakeholders and because of their varied and conflicting interests limits cooperation and in many cases fuels conflict. And then finally, this is what emerges all the threats to emerge. So it all comes together into an ecosystem. Next slide, please. So this is my final point, and it's sort of my takeaway. Given the situation, what can be done? I would say, first of all, we need to strengthen governance. That's a long-standing task to improve both, and it has to do with resourcing the maritime authorities, but it also has to do with continuing to improve the capacity of the governments themselves to manage their resources and to manage their law enforcement and other maritime agencies. It's a team sport. States need to work within themselves to do this, but they also need to work together, and they need to work with others like nonprofit organizations or extra-regional powers. An important element to strengthening governance is improving awareness. I think there's a large amount of understanding of that, and that's why so much energy within Southeast Asian states and their international partners has been focused on improving maritime domain awareness. And we need to do a better job with our very active capacity building projects. So next, we need to take a look at all those stakeholders and see where the shared interests are. If we make a deliberate identification of that, those can be priority places where we can focus our energy. And I think those areas include disaster readiness, environmental protection, fisheries management, transnational law enforcement. None of those issues are ones where there is not at least one set of stakeholders that does not want progress to be made. Yet, I think those are four areas where the majority of the stakeholders, the bulk of the weight of the stakeholding communities do have a shared interest about making progress. And it's where it makes the most sense to focus energy. And then I think there's some threats which are not going to be resolved anytime soon. I do not think the sovereignty disputes in the South China Sea are going to be resolved anytime soon, for example. I think that with climate change, the environmental threats are only going to get worse, and the national disasters are only going to become more dire. So here it's best to focus on managing the threats so that they don't become worse. Promoting the rule of international law and a common commitment to that international governance is essential. I think that it's also important to recognize the role of deterrence. It is strong militaries which prevent states from taking advantage of each other. And it's not an ideal way to deal with it, but it's probably the best way that we have. And I would point out that even though China is much stronger militarily than any of the other Southeast Asian claimants, we have seen time and time again that the weaker militaries, when acting with resolve backed by their national government, can stand up and make a difference. We've seen the Philippines do that. We've seen Vietnam do that. We've seen Indonesia do that. I think dialogue and confidence building, which may have been mostly a theme of 10 or 15 years ago, maybe 20 years ago, needs to come back. I do not believe dialogue and confidence building are going to solve anything, but I think they can help manage the threat. And I think that the cost of doing so is so low that we should at least try it. And then finally, I think it's important to develop in the mutual investment of the community of stakeholders. One of the things we need to do in the South China Sea is we need to break down the barriers between the different communities, and as much as possible promote dialogue and cooperation between the shippers and the fishermen and the militaries and the state governments, etc. Those silos, breaking them down is not going to solve the problem, but breaking them down can help us understand the problem and manage risks. And with that, I'll hand over the microphone to the next speaker. Thank you very much for the time.
Thank you very much, Dr. Bradford, speaking from Singapore. Very interesting to touch our topics, and it seems that the threat is remain in South China Sea, but also lots of opportunity to improve the peace in the region. Ladies and gentlemen, let's move to the next speaker, speaking from Jakarta, Mr. Abdullah Zulkifli, Assistant Deputy for ASEAN Cooperation Coordination at Coordinating Ministry of Politics and Security, Republic Indonesia. Allow me to read short background for Pak Abdullah. He graduated from Bandung Institute of Technology, 1998, from Department of Informatics. In 2008, received master degree in regional studies from University of Indonesia. Now, Pak Abdullah, congratulations, is a doctoral candidate in Indonesian Defense University. Please, Pak Abdullah, time is yours for his presentation.
Thank you, Pak Asep Setiawan, our moderator for today's event. Yes, we just heard recently from our respected speakers, Dr. John Frederick Bradford from Singapore, Professor Donald Rothwell from NU Australia, and Bapak Viramala Anjaya from CSEAS Jakarta. Ladies and gentlemen, good afternoon from Jakarta. Hopefully I find you in good health and safe wherever you are. It is an honor for me to be speaker amongst the top figures in maritime security and maritime law issue. And as you see from my CV, I'm also a student of IDU, Indonesian Defense University, meaning I'm still learning, and I'm very keen to get further insight and knowledge from today's discussion. Let me begin my presentation. Next slide, please. About ASEAN and China cooperation on managing the South China Sea conflict, with how important this water for economic activities for the world and region. Of this important is the energy security. There are 7.7 billion barrel discovered oil reserve and 28 billion barrel estimation of total oil reserve. 266 cubic trillion estimation of natural gas reserve. While huge oil and natural gas reserve are said to lie beneath its seabed, it is also a fishing ground for around 10% of global fish reserve. Further, 1/3 of the world's maritime shipping passes through the sea, including 2/3 of energy supply to South Korea, 50% of energy supply to Japan, and 80% of China's import oil, all carrying over $3 trillion in trade each year. Next slide, please. But the economic significance of South China Sea also has the significance of disputes. The disputes involve both island and maritime claims by several sovereign states within the region, where there are 6 countries have territorial claims over the sea. In 1947, China published its 9-days line, claiming with an ambiguous line roughly covering 90% of South China Sea or 3.5 million square kilometers. In 1997, Beijing shared the first rendering of its 9-days line, extending roughly 1,118 miles from Hainan Island to waters of equatorial Borneo, under China's historical claim of having it in the past. Since 2012, China discontinued to perform land reclamation and building of military installation over the disputed maritime features. Next slide, please. We can see the changes of the island after land reclamation and building military installation in 2018. Next, please. On 22nd January 2013, the Philippines instituted arbitral proceedings against China in a dispute concerning the respective maritime entitlements and the legality of Chinese activities in the South China Sea. In 2016, the Permanent Court of Arbitration in The Hague ruled in favor of the Philippines. The tribunal finds that the China's self-declared 9-days line has no legal basis for its claim to historic right to resources in the South China Sea. The court also rules that none of the land feature fit requirement under the UN Convention on the Law on the Sea to generate a 200 nautical mile exclusive economic zone for China. Many of the features are the result of extensive Chinese land reclamation. The court ruled that Beijing has violated its obligation as a member of UNCLOS, stating that its island building activities have harmed the marine environment and its vessels' unsafe practices have heightened navigational risks. Other than that, the dynamic of the situation in the South China Sea has become a concern for ASEAN, especially since most of the countries that have disputes with China are ASEAN member countries. But on the other hand, China is ASEAN strategic partner to build a peaceful and prosperous region through cooperation. Just recently in Chongqing, the special ASEAN-China Foreign Minister meeting in celebration of the 30th anniversary of dialogue relation was held. Next slide, please. Now let us observe how the development of ASEAN as well as its role in maintaining peace and stability in the region. Next slide, please. Yeah, first of all, let us see how ASEAN has been transforming itself from 1967, when it was founded by the Bangkok Declaration signed by Indonesia, Malaysia, the Philippines, Singapore, and Thailand. ASEAN cooperation stresses respect for national sovereignty, avoiding confrontation, and reaching agreement through consensus. ASEAN has developed norms for building a peace and security region with ZOPFAN, Zone of Peace, Freedom, and Neutrality, 1971, and Treaty of Amity and Cooperation, 1976, as the frameworks for peace and cooperation, not just among its member states, but also with the major powers in the region. Since the late 1990s, ASEAN has pursued cooperation in three major ways. In 2003, ASEAN adopted a commitment to develop an ASEAN community among its own members. This involves three pillars: the ASEAN Economic Community, the ASEAN Political Security Community, and the ASEAN Socio-Cultural Community. Further, ASEAN has continuously engaged with the major powers in political and economic dialogue to enhance the overall security and prosperity of Southeast Asia. The major powers are, among others, the United States, China, and Japan. ASEAN has been sponsoring wider regional cooperation by playing a leading role in the ASEAN Regional Forum to build confidence and enhance dialogue on security issues. The ASEAN Plus3 grouping on the ASEAN with China, Japan, and South Korea, whose activities have stressed financial cooperation and the East Asia Summit. Next, please. Treaty of Amity and Cooperation or famously known as Bali Concord, was delivered in 1976, signed by the 5 founding states of ASEAN, when Indonesia became chair of ASEAN. As mentioned in Clause 1, the purpose of this treaty is to promote perpetual peace, everlasting amity, and cooperation among their peoples. In Clause 2D, settlement of differences or disputes by peaceful means, and renunciation of the threat or use of force. In Chapter 4, it contains article for Pacific settlement of dispute. As of April 2019, there are 38 high contracting parties or HEP to the TAC. Next, please. Another milestone in ASEAN transformation is the ASEAN Charter, which was signed in 2007 by 10 ASEAN member states in Singapore. ASEAN Charter stated the purposes of ASEAN. 1, to maintain and enhance peace, security, and stability, and further strengthen peace-oriented values in the region. Principle that ASEAN and its member states shall act in accordance with the following principles: renunciation of aggression and of the threat or use of force or other actions in any manner, reliance on peaceful settlement of dispute, and in internal ASEAN conflict resolution, member states shall endeavor to resolve peacefully all disputes in a timely manner through dialogue, consultation, and negotiation. As ASEAN has preserved peace and stability in the region, in 2015, it established the ASEAN Community. Next slide, please. Which consists of a political and security community, economic community, and socio-cultural community. This was a substantial step toward regional integration. ASEAN Political and Security Community, as one of the 3 pillars of ASEAN Community, is a forum for interaction to strengthen cooperation in maintaining peace, security, and stability in the region. In 2015, a guideline for achieving this objective called APSC Blueprint 2025, or Blueprint of the ASEAN Political Security Community, which contains 290 action steps or action lines in order to realize the rule-based, people-oriented, and people-centered ASEAN community. And each ASEAN country has translated the action line to the local or national action line. Now, the pertinent question is, what is ASEAN role in managing the South China Sea dispute? Next slide, please. Yes, next. The South China Sea is a strategic area bordering Brunei, Darussalam, the Philippines, Indonesia, Malaysia, Singapore, Vietnam, and China. In some part, there are overlapping jurisdictions between claimant states, which make the potential for conflict in this region is quite high. Since 1990s, Indonesia has holding the workshop on managing the potential conflict in the South China Sea every year. This workshop is intended to provide perspective and alternative solution for resolving the conflict from track 1.5, where not just include government, but also academician and think tank. In an effort to maintain peace and stability in the South China Sea, the foreign minister of ASEAN member countries issued the ASEAN Declaration on the South China Sea, signed in Manila on 22nd July 1992. The principle contained in this declaration, among others, emphasize the need for peaceful dispute resolution and encourage exploration of cooperation related to the safety of maritime navigation and communication, protection of the marine environment, coordinating search and rescue, effort to combat piracy at sea, and armed robbery and illegal drug trafficking. 10 years later, with China, ASEAN issued a declaration on conduct of the parties in the South China Sea, or DOC, signed in Phnom Penh, Cambodia on November 4, 2002. The declaration on the conduct of party in the South China Sea aimed to build confidence-building measures between China and ASEAN to prevent potential conflict in South China Sea. There are three main elements of the DOC: self-restraint, practical cooperation, and the adoption of a code of conduct, or COC. So I will mention some timeline from how ASEAN did between DOC and to transform it to become a COC. In December 2004, ASEAN-China established a joint working group on the implementation of the DOC, GWG on DOC. According to its term of reference, GWG on DOC meet at least twice a year and convey its report and recommendation to ASEAN-China Senior Official Meeting. In 2011, China and ASEAN successfully agreed on the guidelines for the implementation of the DOC Declaration of Conduct of the Parties in the South China Sea. The agreement opened up opportunities for implementation effort of the DOC through the implementation of activities or cooperation project between ASEAN and China in the South China Sea region. It also brought the initial discussion of the establishment of Regional Code of Conduct in the South China Sea, or COC, that now still going on. The COC will function as an operational preventive measure mechanism and aims to regulate the behavior of the state effectively regulating the behavior. In 2012, addressing the different view in the responding to the situation in the South China Sea, the Indonesian Foreign Minister on 18 until 19 July 2012 approached and conducted intensive consultation or subtle diplomacy with ASEAN Foreign Minister regarding joint position. This effort resulted in the agreement of the ASEAN 6-point principle on the South China Sea. The document contained the 6 principles, among others, the full implementation of DOC, the guideline for the implementation of DOC, and continue exercise of self-restraint and non-use of force by all parties. And the last, the peaceful resolution of disputes in accordance with universally recognized principle of international law, including the 1982 UNCLOS. Next, please. Yes. Okay. Next slide, please. In 2016, ASEAN-China released ASEAN-China FM joint statement on the full and effective implementation of DOC. And in the same year, ASEAN-China agreed on 2016 guideline for hotline communication among senior officials of the Ministry of Foreign Affairs of ASEAN member states and China in response to maritime emergency in the implementation of the declaration on the conduct of parties in the South China Sea, as well as the application of the Code for Unplanned Encounter at Sea in the South China Sea. So there is a hotline communication among Ministry of Foreign Affairs of ASEAN member states and China for any emergency situation. Next, please. Code of conduct as the mandate of the OC is aimed to govern conduct or behavior of countries in the South China Sea to maintain peace, stability, and security in the region. The negotiation is currently in the stage of second reading of single draft negotiating text or SDNT COC based on the adopted 2017 COC framework after the completion on field reading in 2019.
Abdullah, please, the times is 1 minute more, please.
Okay.
Thank you.
So I would like to come the latest update from the 19th declaration of conduct in Chongqing, China in June 2021. The second slide after this is the latest meeting regarding the meeting from ASEAN and China. So the latest update is ASEAN and China agree to formally resume the negotiation of COC, which was pending due to COVID-19 pandemic. ASEAN and China agreed to conduct the negotiation meeting in offline manner with alternative option of online meeting. The SOM on the OC to instruct the GWG on the OC to identify provision in COC that can be discussed through online method, such as the preambular paragraph and objective of the COC SDNT. Indonesia is ready to host the next COC negotiation meeting in offline setting should the situation allow for offline meeting. And let me finish by the conclusion, maybe on the third slide after this. Yeah, yes, next again. Next. Next. Yeah. Okay, let me conclude my presentation with the following points. ASEAN remains committed to continue the COC negotiation despite the pandemic. ASEAN should ensure that COC has more weight compared to the OC. COC should be effective, actionable, substantive. And ASEAN should maintain its centrality and solidarity to come up with ASEAN common position despite mounting external pressure. And ASEAN should keep creating conducive and enabling environment through AOIP ASEAN Outlook on Indo-Pacific implementation for the COC negotiation. Thank you for your attention, and I look forward for question and comment from the floor.
Thank you, Pak Abdullah Zulkifli, speaking from Jakarta with the paper titled ASEAN and China Cooperation on Managing the South China Sea Conflict. Just to remind all of the distinguished audience and participants, we have presents 80 persons on Zoom and YouTube's around 26 visitors. So please go for a question if after the last speaker, Mr. Viramala Anjaija, Senior Research Fellow, Center for Southeast Asian Studies. He is a senior journalist and writer from Indonesia. Mr. Anjaya has been working for Indonesia prestigious English daily, the Jakarta Post, for over 25 years. I would like to invite Mr. Anjaya for your presentation. Thank you.
Hello, can you hear me? Hello? Hello?
Yes.
Can you hear me, Pak Asep? Yeah, okay,
yes.
Thank you.
Good.
Thank you very much, my fellow distinguished speakers from Singapore, Australia, and Indonesia, and all the participants from all over the world. Thank you very much, and a good afternoon to you all. My previous speakers explained in full details about this South China Sea dispute. But actually, what I would like to say is the South China Sea is the second busiest waterway in the world. It is a strategic area bordering very, very important countries. The one is China, Vietnam, Malaysia, Brunei Darussalam, Indonesia, and Philippines and Taiwan. So in some parts of the South China Sea, there is an overlapping jurisdiction among the claimant countries, which makes the potential for conflict in Southeast Asia is very high. See, we have a conflict between China and with 5 other countries, and also we have a conflict China with Taiwan and China with Southeast Asian countries. So this is the potential, and also a potential for the conflict. And the second one is South China Sea has been a major flashpoint for years, with several countries claiming ownership of its small islands and reefs and with access and to resources. So my presentation mainly focuses on certain questions. What is at stake in the South China Sea? What is the bone of contention in the South China Sea? Who is wrong and who is right legally in the South China Sea dispute? How dangerous is the situation now in the region? What ASEAN can do to calm down this situation? So I will try to answer the above questions in my presentation. The slide, please. The first slide. The next one. What is at stake in the South China Sea? Just move left side. Yeah. So actually, South China Sea, though it is a rough sea, but it is very rich in natural resources. Like previously, Abdullah mentioned that South China Sea has 11 billion barrels of oil reserves, around 190 trillion cubic feet of natural gas, and 12% of the world's fisheries. World's 30% of the world shipping trade route also passes through this $3.5 trillion worth trade passes through this South China Sea. Next slide, please. Another important factor, this South China Sea caters to 2.2 billion people. Can you imagine? 2.2 billion people, including 1.44 billion from China and 673 million from ASEAN region. Or you can say it is 1/4 of the world population, because now we have 7.9 billion people. So in the South China Sea, it is very important to maintain peace and security and smooth flow of goods. It is very important. But unfortunately, due to one country, there are so many tensions, so many problems, because we do have, like for example, Vietnam has a overlapping territorial claims with the Philippines. Like also we have Indonesia, Vietnam also some problems, and we also have Malaysia, but we never have any tensions. But only the problem comes from the one country. That is the reason why the US and the European Union and India and Australia are all have been showing a very much interest in this South China Sea. So according to the various data, the South China Sea has 4 island groups. One is the Parcel Islands, another one is the Spratly Islands, and the third one is the Jongsha, and the last one is the Pratas. And beside these groups, we also have many reefs, atolls, cays, shoals, and sea mounts. China and Taiwan basically claim 90% of the South China Sea, which is 3.5 square kilometers of area. So they claim, based on a controversial map called 9-line map. It is the mother of all conflicts, all disputes, this 9-line. The first time China published this 9-line map in the shape of under the title of Map map of the Chinese islands in the South China Sea. That was in 1935. Now, next slide, please. Yeah, these are the groups, island groups. Next slide, please. Yeah. So in 1935, they first published this map of the Chinese islands in the South China Sea. On December 1947, China officially published the 11 dash line, not 9 dash line. We used to have 11 dashes in the beginning, but in 1949, when People's Republic of China was established, they removed 2 dashes in the Gulf of Tonkin. That was an effort as a friendly gesture towards North Vietnam, because Mao Zedong wants to please them. So he removed 2 dashes, and then it became 9 dashes only. But recently in 2013, China added 1 more dash. Now it is officially actually the
I think there is some technical problem from Andrea. Okay, go ahead.
Don't know. We don't know. It is very difficult to prove the historical evidence. So that's why it is better to go for the simple method because in 1982, more than 168 countries agreed to an international maritime agreement that is called UNCLOS, United Nations Convention on the Law of the Sea agreement. So under which, sorry, can you change the slide? More slide. This one, yeah. So in the UNCLOS, 168 countries, including China, all the claimant countries except Taiwan, because according to China, Taiwan is not a country. They all agreed to the UNCLOS. According to the UNCLOS, it is very clear, even a small child can understand, because all the coastal states, according to the UNCLOS, have a right to a 12 nautical mile territorial sea. That is one, full sovereignty. And then they have a 200 nautical mile exclusive economic zone. And the third one is the continental shelf rights. China agreed, but it is the same China which has been violating the UNCLOS, which says I have historical rights, I don't follow the UNCLOS. So that is the strange thing. That is the reason why all these tensions, conflicts are going on. So in this process, I think go to the next slide, please. Yeah. China has been using several strategies. One of the famous one is the cabbage strategy. So under the cabbage strategy, China will send large number of ships to the contested islands, like wrapping leaves around a cabbage. And also, I think it did same thing in the Philippines territory of Ayungin Shoal, as known as in English, it is called the Second Thomas Shoal, to put a blockade. So the shoal is actually located inside the Philippines exclusive economic zone. And they also have called another strategy, salami slice. Under this, they will say, they will see the situation. If the claimant country is weak, is not alert, they will move into their exclusive economic zone. And then if there is international criticism and the claimant country protest strongly, and then they will move two steps backward. It is like our Pocho Pocho dance, actually. Then also they have now the new generation of diplomats who are called wolf warriors. So they always support in the media and everywhere to defend China's historical claims in the South China Sea. Now the question is, next slide, please. Who is right and who is wrong? Of course, I mean, we are not going for the historical evidence, because which is very difficult to prove. For example, I will say before during the Second World War, this entire South China Sea was occupied by Japan. So shall we say it belongs to Japan? Indonesian maritime kingdoms like Majapahit and Sriwijaya empires, they used to control or occupy several territories in many Southeast Asian countries in the past. Shall we claim our historical rights there? Like, like Vietnam, Philippines, and many countries, these kingdoms used to have some influence. Even if you take the China was ruled by Mongols. Shall we say now Mongolia has historical rights over China? So that's why this UNCLOS is the best way to follow. But unfortunately, China is the only country which do not follow the UNCLOS. Of course, we have Taiwan, but Taiwan is not aggressive as China. In 2012, China started a very aggressive act, which is completely against the UNCLOS. It began a land reclamation project to create seven artificial islands. It reclaimed, I think, around 3,200 acres of land and built islands of Kwartan Reef, Fiery Cross Reef, Garven Reef, Hughes Reef, Johnson Reef, Mischief Reef, and Subi Reef. So it converted some of them, these islands, into military installations. So actually in 2012, China occupied Scarborough Shoal, which belongs to the Philippines. Then that's why the Philippines became upset, and it went to the Permanent Court of Arbitration in The Hague under the Annex 75 of the UNCLOS in 2013. So actually, it is the same China which signed, which is a signatory, they call it contracting party to the PCA. It agreed, approved all the regulations, mechanisms of the PCA. And also, it also the same country which agreed, signed, ratified the UNCLOS. But in practice, it doesn't want to follow these two. So it, of course, China has every right to boycott the PCA arbitration. So they boycotted it, but because this PCA was established under the UNCLOS, so that's why China has an obligation to comply with the ruling. It's not a ruling actually, it is an award of the PCA, because the PCA award is a permanent and also mandatory. All the contesting parties must implement this ruling. But until now, it is on next Monday, July 12, it will be already 5 years of this PCA award. But China still refused to implement this award. So that is a very negative aspect. Actually, it is Indonesia, Philippines, Vietnam, Malaysia. We are all calling that China should respect the PCA award, and also it should respect the UNCLOS principles. But how dangerous is the situation now? Now we are facing the corona everywhere. Next slide, please. Yeah. So the PCA ruling clearly declared that China's 9-line or 10-line is deemed legally invalid. And also Scarborough Shoal should be open to the traditional fishing. China's land reclamation activities are cause severe damage to the marine environment. And also China's oil exploration activities in the Reed Bank also are not according to the international laws. So this is the PCA rulings. Next slide, please. Next slide, please. Yeah. Then after this PCA ruling and China's activities in this South China Sea area, actually the US responded that China China's installation of this military troops, weapons, and in South China Sea, actually it is obstructing the freedom of navigation in the South China Sea. So that's why the US sent freedom of navigation operations. It is called FONOP. So they sent several warships to this area. That's why now I think the UK, France, Germany, Canada also following these operation to defend the freedom of navigation and freedom of overflight. So under this tense situation, can you go to the next slide, please? Yeah. So what ASEAN can do? Before we can go to this ASEAN can do question, actually I would like to remind you people all that in this dispute, it was the only China that used violence, because in 1973 they attacked South Vietnam forces and took control of the Parcel Islands. Then again, they also attacked Vietnamese forces South Johnson Reef. So it was the only China which used the force. No other country, no other claimant ever used the force. So it is the only China which used the force, but unfortunately China is the third biggest military power in the world, and it is now the second largest economy in the world. So that's why ASEAN must design a strategy how to deal with China, which is very aggressive, very aggressive. Even if you take the words of the US, they say, oh, China has been bullying, coercing these small neighbors. So that's why, frankly speaking, ASEAN is a weak organization. Sometimes people call it as a talking shop. But there are so many interesting things about ASEAN which we never think about. ASEAN is a
please
dynamic.
remind 1 minute more, please.
Yeah,
the time is 1 minute more, please. Thank you.
Yeah. So can you go to the next slide, please? Yeah, there is a new trend, because earlier for 12 years ASEAN used to be the China used to be the ASEAN's biggest trading partner. Only last year ASEAN became the China's largest trading partner. What it means? That means ASEAN has a clout against China. So that's why we have more trade with China, and also the Chinese ASEAN investments are bigger than Chinese investments in ASEAN, and more ASEAN tourists visit China than this. So that's why it is. And also you can go for the third, another one for another slide, please. Another slide. Yeah, this is an important one, because according to the global firepower, that actually if you combine all the troops of ASEAN, which are equivalent to Chinese troops, then also we have actually we have more tanks than China if you combine together, and also we have more warships than China. Of course, China's defense budget is very huge, because all combined ASEAN defense strategy, defense budget is only $44 billion. So what I am saying is ASEAN must be united. That is it is prime most strategy to counter or to deal with China. Then our previous speakers explained about the DOC and the COC. But COC, if it is legally binding, if it is according to the UNCLOS, China will not accept it. So that's why they have been trying to delay, or they want to dilute the content. But the ASEAN must be united and demand fully with one voice that everybody, not only China, not only Taiwan, all claimants must follow international principles, UNCLOS. That is the basic thing. And then second, now the International Court, Permanent Court of Arbitration, PCA, awarded that said 9-dash line is no longer, so that we can sit together and discuss. It should be implied because otherwise China should not have a signatory to the UNCLOS if it wants to claim the historical rights. Thank you very much, Pa Sep. Then I will try to answer if you have any questions. Thank you.
Thank you very much, Mr. Anjaya,
Yeah.
for presentation. Very interesting. And still we have Professor Rotba from in Canberra and Mr. Bradford, Dr. Bradford from Singapore, and two panelists from Jakarta, Anjaya and Mr. Abdullah. And we have a question and answer now. Basically, we have received a lot of questions, but please allow me to read for all panelists. The first question is from Dr. Kogila Balakrishnan, University of Warwick, UK. This is question for all panelists. There seems to be a strong will for collaboration between the ASEAN to sustain stability in the region. The question is, are there efforts by ASEAN countries to develop joint capability intra-ASEAN as well as with the friendly partner nation for this purpose, and what are these initiatives? I would like first, Pak Rothwell, Mr. Professor Rothwell, do you have an answer for this question?
Thank you, Chair. No, look, I think I'll defer to my colleagues who are much more knowledgeable about ASEAN matters.
Thank you, Mr. Rothwell. Pak Bradford, Mr. Bradford.
Yeah, I think there is, generally speaking, a will for collaboration and a desire that these threats are problems. Unfortunately, if you go back to sort of the STAG analysis that I provided, I think there's just enough disunity amongst the stakeholders that we don't manage to get real consensus on any solution. And even those small things which could be done through consensus get lost in the larger conversation. So at its most basic level, if you ask the question of one of the threats, which is the competition for sovereign control or legal control and exercise of the rights and responsibilities of the coastal state in the South China Sea, the ASEAN countries have not been able to reach sufficient collaboration because they disagree on the strength of their pushback towards China, the state which was already noted to be the most aggressive and the only one to have so far used force to assert those claims. I won't belabor the point, but I think on the other issues, you have even more divergence. One of Bakanjaya said that only China has used force in the South China Sea. That is absolutely true as long as you make the point that China is the only state to have used force against another state. There are plenty of coast guards and militaries which are out there using force against IU fishers and other criminals. And when those criminals are sometimes supported by one state, it becomes or protected, maybe is a better word, by one state, it becomes very complex very quickly. And I guess I would just leave by note that, the most violence which takes place in the South China Sea, and it's constrained. I don't want to say it's like a really bloody place, but, go on YouTube and watch videos of violence at sea. And it tends to be between the coast guards and navies of one ASEAN state against the civilians of another ASEAN state.
Thank you, Mr. Bradford. Mr. Abdullah Zulkifli, I think you mentioned a lot of ASEAN-China cooperation. Do you have in mind what you are going to answer this question?
Yes, Pak Asep. Thank you, Dr. Balakrishnan from University of Warwick for the question. And between ASEAN countries and China, a lot of practical cooperation, like let's take example from the OC. There is a cooperation on marine environment and transnational crime. And the other forum or or organization cooperation under ASEAN like ADMM and ADMM Plus that include China and US. There are a lot of practical cooperation too, like in cybersecurity, disaster relief, humanitarian assistance, and including exercise between joint exercise between military. So I had many people say that ASEAN have talking shop, but in the talking shop situation, you can find maybe one or two practical cooperation that can be managed by between ASEAN and ASEAN partner. Just in 2019, we have ASEAN Outlook on Indo-Pacific, where we want to make the region focus on key element of cooperation like maritime security, connectivity, economic cooperation, and SDGs. So this is a challenge. These are challenge for ASEAN to implement the agreement, implement the statement into the practical cooperation. So far, as from my point of view, many discussions that include China, US, Russia, and many regional powers, which ASEAN can make them sitting together and speak and find at least a common position. Maybe we acknowledge the conflict that happened, but we can find some common cooperation position that we need to maintain the regional for peace, stable, and secure. And then I think we still have a lot of cooperation, but maybe it's not a big thing, but for some issue like transnational crime, marine environment, and I think in other pillar like economic pillar and socio-culture pillar, there are a lot of practical cooperation as well that include ASEAN member and ASEAN dialogue partner. Thank you, Pak Asep.
Thank you, Pak Abdullah. Let's move to the next question. Pak Viramala, any answer for this the first question, or we can?
Yeah. Thank you. I have some comments. First thing is, since 2015, ASEAN has become an ASEAN community. We are a community. We are a family. But unfortunately, if you see the reality, we don't have that community feeling. For example, in 2019, the Chinese fishing boats, all the way thousands of kilometers from the Chinese mainland, entered into our North Natuna Sea, which is our exclusive economic zone, escorted by the Chinese naval ships. They were catching fish, which is illegal according to the UNCLOS. But unfortunately, no ASEAN country has ever condemned. Likewise, recently, around 16 Chinese military planes intruded into the Malaysian airspace. Again, no country has ever condemned. In Philippines, this year again, a few months back, they surrounded one reef which is inside the Philippine exclusive economic zone. So it is ASEAN is not working as a family, as a community. So that's why Indonesia, as a de facto leader, has been making some efforts to convince all the countries come together, because ASEAN unity is the vital, because that is the only way we can stay united, because it's the same thing happened in the European Union, NATO, that they stayed together, small states stayed together and defended strongly against mighty Russia. So like, I think the similar situation is coming into the Southeast Asia. So, but of course, we have not reached that stage. So that's why people do not see China has been trying very hard to divide the same ASEAN. We talk about ASEAN unity. They wanted to divide, like Abdullah mentioned that in 2012, China was succeeded in when ASEAN summit was there in Phnom Penh. So it was succeeded, and then Indonesia sent its foreign minister to conduct a shuttle diplomacy to diffuse the situation. So that's why China has been using for its interests in the South China Sea dispute. I think they are using Cambodia, they are using Laos, they are using to a certain extent Myanmar. So that's why now there is a new trend many people are not noticing. Actually, in the United Nations, we have already been working, though not officially, like with Indonesia, Malaysia, Philippines, Vietnam. These 4 countries are working closely, informally. So that's why this we have to put before the other ASEAN members, that we want peace in ASEAN. That is our main goal. We want this region is stable, and this region must grow further. So that's why we should stay united. But actually, ASEAN countries can do, if they all unite together, they can do. I told you, in terms of economy, in terms of military, in terms of all other actions, they can do. Even if not other non-claimant countries in ASEAN, they don't agree with this principle, at least these 5 countries like Vietnam, Malaysia, Philippines, Brunei, and Indonesia must form a kind of forum. Like, for example, then this forum will get a huge support from international players also. Like, for example, we have already the Quad, US, Japan, India, and Australia, and they are proposing an Indo-Pacific strategy. And also we have a nuclear neighbor, India, next to our borders. They are also ready to support the ASEAN countries' slogan that every country must follow international regulations and freedom of navigation must be respected. So that's why the ASEAN countries think again. Why we are a family? Why we are not working as a family? So that is the question. Thank you.
Thank you very much, Pak Viramala, for the explanation. Let's move to the next question. This is the question is specific for Professor Rothwell. Please allow me to read it. The question. This is the question from Sumati Permal. The 2016 award made significant influence to the South China Sea dispute management. How important and how much the ruling holds vis-a-vis the current South China Sea development, in particular on the ground activities including VONOP? Please, Professor Rothwell.
Thank you for that question. So I think I should just make some basic points to begin with. The first is that the award in the South China Sea case was not a decision of the Permanent Court of Arbitration. It's a decision handed down by what's called an Annex 7 arbitral tribunal established under the Law of the Sea Convention. The tribunal was hosted by the Permanent Court of Arbitration, and unfortunately that's created an enormous amount of confusion in some of the literature and some of the commentary, but it is an important point to note because the Permanent Court of Arbitration is a separate body. It actually is not affiliated with the framework of the Law of the Sea Convention. The second point to make is that the decision is final. It's binding. And notwithstanding the position taken by China, it is bound by the decision, especially since it's a party to the Law of the Sea Convention. So China cannot contest the legality or the legitimacy of the award because it's a final and binding decision of a legitimately constituted tribunal. Now, in relation to freedom of navigation operations in the South China Sea, the decision in the South China Sea arbitration doesn't directly address freedom of navigation issues, and it certainly didn't address freedom of navigation as exercised by the United States in particular. It has consequences for navigation because, as I observed in my comments, the view of the tribunal was that none of the features in the South China Sea were islands, consistently with Article 121 of the Convention, and that if those features were recognised under the Convention, they were at a minimum rocks, and that as rocks, they certainly generated territorial sea. But within the territorial sea, the vessels of all states, both parties to the Convention and non-parties to the Convention, enjoy the right of innocent passage. And most importantly, that right of innocent passage extends to both warships and to merchant ships. I think I'll leave it there, Chair. Thank you.
Thank you very much, Professor Rothwell. As any addition for the others? Let's move to the next question. The question is basically from Ms. Tracy DVNA. This is about code of conduct. What are the scenarios of code of conduct? What are the differences between involved stakeholders approach? Pak Abdullah, I think you touched a lot about code of conduct. Can you answer this question, please?
Yes, thank you. Can you repeat it again, the questions?
The question is very simple. So what are the scenarios of code of conduct? What are the differences between involved stakeholders approach? So this is thank you.
Yeah, so far, the scenario for code of conduct is already agreed for single draft negotiation text, that it be continued for first reading, second reading, and hopefully can be agreed after some discussion by joint working group on COC. I think the challenges ahead are that potential flare-up of conflict with China's increasing assertiveness in South China Sea. So the code of conduct is not happen in vacuum. It's related with the environment, with the situation, with what happened. It will affect the negotiation. Like just recently, we have pandemic, and it postponed the negotiation of code of conduct. And the challenges number 2, maintaining ASEAN unity and solidarity to achieve ASEAN common position during COC negotiation. As Pak Anjaya has already told us that ASEAN need to united, and that is one of the challenges in negotiation of COC2, that we need how to maintain unity, centrality, and solidarity in ASEAN, between ASEAN member, how ASEAN can come in one position. And the other challenge also, if COC already agreed, how the implementation of COC for countries outside of ASEAN and China, because in the South China Sea, we can meet a lot of countries also with the situation that may be described in COC. What it should be done to other country outside of ASEAN and China, and also how the dispute settlement mechanism happen and monitoring mechanism of the COC. So COC more for the conflict management. It's not. It will not solve the dispute of the what happened right now, but mostly for the keep the region in peace and stability in the region. I think that the challenges. So we need to do a negotiation, and with these factors also need to be considered.
Thank you, Pak Abdullah. Thank you, Pak Abdullah, for your perspective. And I heard that before Mr. Bradford explained about the steps toward improve peace and security in the region. Do you think that COC concept is suitable for the region, in particularly South China Sea area? Mr. Bradford?
Oh, sorry, I didn't realize you were addressing the question to me. I have low confidence that going from a COC to a DOC, even if it successfully, that the transition is successful, that this will solve the problem. I mean, if the problem is a matter of territorial dispute, this is not going to take away the issue of territorial disputes. However, I kind of said at the end of my presentation, the goal is to manage the tensions and to prevent conflict from emerging. And in that way, going from a COC and strengthening it to a DOC is a positive step forward. Now, of course, the barrier is, given the divergent interest of the various different parties that would sign that, whether that be China or an ASEAN state, how do you make such a code which preserves everyone's interests and protects the region from further instability? I think that's a really hard challenge, given how everyone's interests are different, and that's why it's taken so long. So, I would say I'm not overly optimistic, but I'm so glad that people are hard at work trying to do this. So I applaud all the diplomats that are doing their best, and I'm hopeful.
Okay, thank you, Mr. Bradford. Pak Anjaya, do you think that COC, because you mentioned these things before?
Yeah,
Think
thank you. Yeah, thank you. So before coming to the DOC and COC, we have to see China officially acknowledged that it has overlapping claims or disputes with these Southeast Asian countries. That is a very good sign. They agreed. But it is the same China which said that it is a dispute between you and me. Like, for example, China versus Vietnam, China versus Philippines, China versus Malaysia. It is not a regional dispute. So that has been the China's strategy, China's policy. But if you see the reality, it involves so many countries and they have their overlapping claims between everybody. So that's why ASEAN has realized this in 1992, I think. They started, we have to negotiate, at least not to solve the problem, but Mr. Bradford just rightly said, to how to manage the tensions, how to manage the interventions, so to have a peace. So that's why ASEAN proposed this DOC. It took 10 years, almost 10 years. At the end, they agreed to a toothless DOC because we have the history. China signed the UNCLOS, it never implements. China signed the PCA, it doesn't respect its award. And also now the DOC signed, still since 2002, how many violations of the DOC have occurred? You can see the list is so long, so lengthy. Then that's why after that, after in 2003, I think they started negotiation, floating the idea. ASEAN countries have been discussing we should have a legally binding, a very powerful, and which is according to the international laws, we should have a code of conduct. Then they drafted this code of conduct, but I think only in 2018, I think, finally China, they convinced China to have a common draft. But I met several Chinese scholars who told me in person that if this code of conduct is against the interest of the China, it may not sign the code of conduct. It may drag into years, and it will dilute it. But for ASEAN, it is very simple and very easy. First, ASEAN countries must agree on two aspects. The one is follow the UNCLOS, International Maritime Laws, which China also signed. ASEAN countries also signed. That is one. The second one is international court. Of course, it is not a international UN body, but according to it was established according to the UNCLOS, the PCA award must be respected. So if ASEAN countries, all these agree on these two principles, and then they come to a common stand on the COC, then the negotiations will not go long, because ASEAN is one voice, China is one voice. China doesn't have a playground to play. Oh, Cambodia says no, Laos says no, Myanmar says no. No. So that's why ASEAN must tighten its screws and to stand as a united force, to agree COC with one voice. So that's my opinion. Thank you.
Thank you very much, Pak Veramala Anjaya. Pak Mr. Rothwell, can I ask, do you think that the solution and approach to South China Sea conflict is enough with the just code of conduct rather by international law approach?
No, actually, code of conduct is not to solve the South China Sea conflict. No, not at all. Like, for example, like in the last April, so not last April, sorry, actually, it was, just a minute, I will tell you. Yeah. In March this year, 200 fishing boats of China entered into Philippines exclusive economic zone, and they surrounded Whitsun Reef, which is completely inside the Philippines economic zone. So it is a violation of the UNCLOS. So that's why, if we have a code of conduct, so it is a legally binding. So the mechanism which China and ASEAN agree, they will take sanctions or measures to prevent this kind of intervention. But it is not a way to solve the South China Sea dispute. It is, in my view, I think this problem will be solved only if the Antarctica continent melted. Then this South China Sea will not be a strategic waterway. But of course, China knows this problem, and it is going now. With the arrival of the international players, China has been trying to find an alternative, like building a Gwadar port in Pakistan, and also they want to build a port in Bangladesh. They want to build a port in Myanmar, so that all its energy exports, imports will not pass through Indonesia's Malacca Strait and enter into South China Sea. So they are always already been working to dilute the strategic importance of South China Sea as well as Indonesia's Malacca Strait. Yeah, thank you.
Thank you, Pak Anjaya. I would like to ask Mr. Professor Rothwell on these matters from international law perspective on COC regarding South China Sea.
Thank you, Chair. So, in my presentation, I sought to emphasise the importance of the legal framework created by the Law of the Sea Convention. So, there are only two actors in the South China Sea region that are not parties to the Law of the Sea Convention. One is Taiwan, and John Bradford addressed that issue there. The United States, of course, is not a party to the convention, and there's always debate and discussion as to whether or not the United States might seek to accede to the convention. But the principal United States interest in the South China Sea from a Law of the Sea Convention perspective is the freedom of navigation and is the recognition of maritime claims and entitlements, of which the basic principles are all fairly well established. The other point I'll make is that all of the littoral states in the South China Sea have in one way or another sought to use the Convention on the Law of the Sea to make submissions to the Commission on the Limits of the Continental Shelf in terms of seeking to have legitimated their claims to a continental shelf beyond 200 nautical miles. So South China Sea states, including China, recognize the importance of that particular process. Now, there are legal and technical issues in terms of how that proceeds. But the important point is that the states within the region recognize the legitimacy and the importance of the Law of the Sea Convention. And indeed, the Declaration on Conduct, the DOC, directly refers to the Law of the Sea Convention. And some of the circulated drafts, early drafts of the COC, presumably would do the same. So I'm in agreement with John Bradford. I'm skeptical about how significant a COC could be, but if it's a confidence building measure in terms of reaffirming some of the key principles of the Law of the Sea Convention, well, I think that's a good thing.
Thank you, Professor Rothwell. John Bradford, do you want to add something on this case?
No, I will. If someone says they agree with me, I'll double down and say I said the right thing, and I'll ask to go to the next question.
Okay, right. Thank you. The next question maybe is related to the ASEAN position. This question is from Mr. Dafri, Dr. Dafri Agus Salim. This is related to the ASEAN basically. Do you think that ASEAN principles should be redefined or revised in order to make ASEAN centrality more effective in handling the security issues in region, especially South China Sea issue? What is the impact of South China Sea problems on the non-traditional security issues in the region? I think the first question is whether the ASEAN should be redefined, revised, the centrality, more effective handling the security issues in ASEAN. I think Pak John Bradford is a touch of the ASEAN, whether this is the tools to, you know, to have a solution in South China Sea problem.
That's a really hard question. And I think it would probably be presumptuous of me to give a strong recommendation. I do think that given the current dynamics and the current rules under which ASEAN operates, essentially non-interference and consensus, it is going to be very hard for ASEAN to solve this problem. That is not to say that ASEAN should not be the central spoke or a key team which tries to address the problem. I think that the question of should we redefine or should ASEAN redefine itself is it's almost an impossible question. I think most people who suggest it already have an idea of what that new definition would look like. And if they do, then they should say, should it change to be different in X way? And we can evaluate that. Because some people think the answer to regaining ASEAN centrality is to weaken ASEAN, so consensus is not required. Others suggest that it would be to remove members that have different opinions. I'm not advocating for either one of those, but some people are. So I think that that would require a real discussion that goes further beyond a Q&A here. And I'd be more interested in learning than contributing to that debate.
Thank you, Mr. Bradford. Pak Viramala Anjaya, do you think that if you look at the ASEAN, the ASEAN has what so-called is a regional security forum? Do you think that is enough to deal with the South China Sea maritime borders conflict?
Yeah, thank you, Pa. Thank you. Actually, originally in 1967, the founders of ASEAN established this ASEAN as an economic union, not a political one, not a security one. So more than 50 years, ASEAN has been moving very smoothly on the economic part. But I met a former Thailand foreign minister who suggested that it is the time now for ASEAN, because ASEAN has already become a community, so time to work for the political union, because economic union we achieved a lot, but political union we are at the lowest level, so it is a time to achieve the political union. Maybe I think the ASEAN centrality question, I think the ASEAN should just simply change the mechanism to take decisions. from unanimity or unanimous to majority of votes. That will change, because a small country like Cambodia cannot take hostage of entire ASEAN. So like as Laos cannot take hostage. So that's why the ASEAN must think twice and thrice and forth to work for the political unity, and then they change the rule. The majority of the states' will should be respected, because we are now, we are living in the 21st century. So that will solve this kind of differences. And then as far as the ASEAN Regional Forum is concerned, that is a great political security body in ASEAN. That is the only one security forum in entire Asia. So that's why where all the big players from China, from East Asia, from Asia Pacific region, they all join together. It is a forum. But now the situation is moving very fastly because of this conflict, strategic conflict between China and US. We are moving towards in that direction, which is similar to the after the Second World War in the Europe. So now I think ASEAN countries also, not only the political union, they should also think about the security union, whether common joint patrols, whether they have to do it. But of course, they have to change their minds, their organization, the decisions, everything they have to change. So that is my opinion. Thank you.
Thank you very much, Mr. Anjaya. Next, the question is related to the law, basically. It comes from Mr. Angga Reza from Indonesian Maritime Security Agency. The question, particularly to all of you, distinguished panelists, what is the prospect of white hull diplomacy between Coast Guard and or maritime law enforcement agencies to establish security in the region and in order to reduce tension in the context of military aspect? So we could shifting our approach from military approach become non-military approach.
May I?
John?
Yeah, I actually think this is a really interesting question. About 10 years ago, there was a large advocacy, including among navies, arguing that using coast guards or even creating coast guards, because remember, some of, as you guys well know, some of the Southeast Asian coast guards are quite new, especially if you include Bakamla as a coast guard, and that's the newest of the bunch. And so there was a large, in the Track 2 community, there was a large argument that Coast Guards should take over these roles from navies, because as white hulls instead of gray hulls, it would be less escalatory. I think that was a very noble idea. And I think now that this is basically what's been happening for 10 years, there are pros and cons. On the one hand, the fact that Coast Guards are the frontline responders, which are coming into conflict, means there are less options for escalation because the ships just can't fire as big of weapons at each other. So that's useful. But on the other hand, in some ways, it's removed some of the political space available, and maybe it's even problematic. For one thing, now you've conflated sovereignty assertion with law enforcement. And obviously, the two things are always linked in a way. But when states start going and purposefully enforcing laws in areas specifically, not so much to enforce the laws, but to assert their sovereignty, now you have law enforcement vessels which are upping the political ante and creating more tensions. And this is definitely true in the South China Sea, but I think the even clearer example, because it's the same strategy, but because there are less complicating factors and less stakeholders, you can more clearly see this around the Senkaku Islands, where both Japan and China are using their coast guards nominally to do law enforcement, but without any transparency, absolutely doing that just to assert their administrative control. And you see a very similar dynamic, except there's a lot more players, so it's and less awareness, so it's a bit more confusing in the South China Sea. So I think that we need to do a lot of thinking on a new reality of what it means when your white holes are being law enforcement agencies, safety agencies, but also enforcing, being used to enforce sovereignty. And the last thing I'll say on that is, this has become more apparent and more discussed with the passage of China's new Coast Guard law, where they deliberately say that their Coast Guard is to do this. But China is not alone in using its Coast Guard in that way. So pros and cons, and a really fertile area, I think, for some real strategic thinking.
Thank you, John Bradford. Professor Rothwell, do you think that there is examples in other areas that the approachment of law enforcement is one way? There is one step to to gather all of the claimants or something.
Thank you for that question. Look, I can certainly think of examples where countries have mutually come together to work together in mutual interests with respect to law enforcement. In my part of the world, we can see that in terms of cooperative fisheries law enforcement in the Southern Ocean between Australia and France, and also in some cooperative fisheries law enforcement that takes place in the South Pacific. And that reflects a mutual interest amongst the relevant states. But to pick up on a point that John was just making, in those parts of the world, there's no contestation over sovereignty. So there's a mutual interest in law enforcement. There's no dispute about sovereignty with respect to the relevant territories. So the relevant countries are very happy to come together and work jointly together in that sort of law enforcement type setting. So mutual law enforcement really requires some very strong confidence and understanding between the relevant coast guards and relevant law enforcement authorities. And if you don't have that, you won't be able to undertake that sort of mutual activity, it seems to me.
Thank you, Professor Rothwell. Pak Abdullah, do you have something to explain about this approach from Angga from Bakamla about the law enforcement approach?
Yes, Pak Asep, following how the law in China now can let the Coast Guard to do some hard law enforcement for any law breaking in the South China Sea, and we can see many different of authority and power of Coast Guard. I think it's we need to set up a common standard for Coast Guard, and in ASEAN there is since 2018, correct me if I'm wrong, there is a ASEAN Coast Guard Forum, and Indonesia is active in this forum. I think can make a concern about this situation in the forum, so ASEAN Coast Guard can come as one voice and one position. So that's all. Thank you.
Thank you very much, Pak Abdullah. We still have about 15 minutes before the end of the session, so please stay us. We still have 83 participants in the Zoom meeting. The last question is regarding the external power. So this is a very interesting question for all of the panelists. I received the question from YouTube audience. The free and open Indo-Pacific strategy is the strategic framework put forward by Japan, United States, Australia, and India. We call it the Quad. The countries that oppose China's action in the South China Sea. The question is how effective the Indo-Pacific strategy deal with the South China Sea issue. Mr. Bradford, first, do you have? how the external power, you mentioned about external power.
So I did. I think it's as effective as anything we've got. And let me address that in two ways. So first of all, one of the things I talked about in terms of managing the issues is deterrence. And deterrence has not been successful in all ways, but I think it actually has been fairly successful. And this is what I mean. There's a lot of complaints or observations, perhaps is a better term, that China uses salami slicing tactics or gray zone tactics or cabbage tactics, different names for it. But what this essentially means is that China elects to take steps to serve its own self-interests without directly creating a reason for there to be conflict. And the reason China is doing that, and the reason China has to work slowly and carefully, is because deterrence is, generally speaking, effective. Now, that said, it has been cutting lots of slices of salami over the last 10 years. So therefore, deterrence is not perfect. There are a lot of things which can be done to deter these sorts of negative activities. I think one of the most effective is international unity, and I think that has been lacking. But I think that military strength of whatever sort is also useful. And as I mentioned earlier, even countries with very weak navy, such as the Philippines, have been able to show that resolve and successfully block maneuvers by China. So what does this come around to as far as the external powers? I think that generally speaking, when the external powers are stronger and more coordinated, then it creates more reason for China to pause. So in that way, it's generally a good thing. However, the Quad is not a military alliance. The Quad countries are not going to go to war against China together. They're definitely not going to go to war with China together over the South China Sea, unless the scenario is an affront to global stability or a complete abrogation of international law. And even in that case where I say unless, I think a lot of things have to happen between now and then. We don't see it happening anytime soon. It's not a military alliance. There's a great deal of divergence between the four countries. So while the four Quad members exercising militarily together, building their interoperability, developing joint logistics, etc., is all generally a good thing. I think that the most powerful thing that the external powers can do, and what I strongly advocate they do more, is to build capacity of the Southeast Asian states. And I don't think that's necessary to say build capacity to go and resist China. In fact, I think that's the wrong pattern. I believe that the external powers should work with their bilateral partners and with ASEAN to develop generalized maritime capability. And that allows the maritime states of Southeast Asia, Malaysia, Indonesia, Philippines, etc., to better address all of their maritime threats. And that will generally create two things. It will create better governance. It will create, well, actually three things. It will create better governance. It will create better awareness. And it will create more confidence. And all three of those things will be a positive towards the South China Sea. Is any of this going to change things overnight? No. But I think that's the direction we should take. And while I have the microphone, this may be my last time, I also just want to caveat one other thing. I think that the cooperation that has been inspired by, driven through, and within, by directly between ASEAN members on maritime issues in general has been incredibly effective. This is when we go back to the question of what are the South China Sea issues? Has it been effective in the question of contested sovereignty with China? No, not so much. But in terms of piracy, drug smuggling, people smuggling, counterterrorism, it's been incredibly effective. Perfect? Not yet. But like cooperation in the Sulu Sea means that we go from where we were 20 years ago with Abu Sayyaf running amok to now a few small cases here or there. Piracy in the Strait of Malacca and Strait of Singapore has been almost wiped out, not completely. In COVID, we're seeing a small surge, but that has happened because of cooperation between ASEAN states. And in some places, this is ASEAN itself. But in other cases, it's that community which is enabled by ASEAN, which allows localized cooperation. So, you know, I kind of, some people might have been, I'm going to close with this one statement. Some people may have misunderstood my statement about Coast Guards being a mixed bag. I think they're a mixed bag when you're talking about contested sovereignty. But in terms of general maritime security in the region and addressing the threats of today, I think they're doing an incredible job and they need to be empowered to do more.
Thank you, John, for your answer. I think this also the summary, our
Yes.
workshop. I would like to invite Mr. Donald Rothwells to answer the external involvement in the regarding the solution of the maritime dispute in the other area, and I would like to ask also the closing statement of our workshop today.
Thank you, Chair. Well, for the second time this afternoon, I'm going to agree with John Bradford. I endorse many of the comments that he just made. Look, the overarching framework in terms of external involvement in the South China Sea is that United Nations framework that I spoke about at the start of my presentation, and recognising that 168 states are parties to the UN Convention on the Law of the Sea. Every state has an interest in the South China Sea, just like every state has an interest in the Atlantic, in the Pacific, in the Southern Ocean, Indian Ocean, and also in the Arctic Ocean, because that Law of the Sea Convention establishes and sets down some very fundamental principles which were strongly negotiated during the 1970s, which seek to gain a balance between the interests of coastal states and the interests of maritime states. And that's why the freedom of navigation is really so critical to all of that. And some of my fellow panelists this afternoon have emphasised that in the context of trade and commerce throughout the South China Sea, not only benefiting China, but of course all the other ASEAN economies. I will just add to the significance that John has highlighted with respect to the Quad to say that there are reports that both the United Kingdom and France are sending warships to the region to engage in joint military exercises with the US and Japan, and we'll see that coming over the next few months. That's a very strong indicator that two other countries, two permanent members of the Security Council, and relatively significant military and naval powers are also interested in demonstrating that some of these key principles that we're talking about in terms of freedom of navigation, especially, need to be upheld in the region. Thank you, Chair.
Thank you, Professor Rothwell. I would like to invite Pak Viramala Anjaya for a closing statement and the comment and the last question, please.
Yeah, thank you. Actually, we are now living in a global situation where the dominant power, the US, is declining both economically, militarily, technologically, whereas the China as a new player, it has been emerging as a big global economy, global military power, even technological power. So it is a transition from one global hegemon to another. So the China is challenging the US and other European powers. So it want to show that it is the new player, new hegemon. So these US and European Union and Australia and India, all other countries, they see China as a big threat, because you can see China has problems with Vietnam. China has problems with Philippines. China has problems with Malaysia. China has problems with Indonesia. China has problems with Taiwan. China has problems with India. China has problems with Australia. China has problems with the European Union. Many countries. So it has become a global problem. Whereas during the Deng Xiaoping period, China used to be a peaceful rise. They don't want to dominate the world. But under His Excellency Xi Jinping, the situation has changed. They want to project their power globally, even through the BRI, the Belt and Road Initiative. They want to control the global economy. The China's words now are coming as a same situation like when in the European, which led to the Second World War, First World War. So it is a transition of hegemonic power from one power to the other. So now we recently just see on the July 1st, on the anniversary of the 100 years of the Chinese Communist Party, President Xi Jinping used the very strong words. He alleged that we don't tolerate any bullying from the US and other powers. See, so actually the words coming from Beijing are actually as if they are preparing for a war. So that's why we Southeast Asians, we don't want any war. We don't want any war. We want only peace. We want to work with China. If China agrees, which it agreed, but it is very difficult to trust it because it agreed many times it is never implemented. So that's why we need peace. So that's why in order to get the peace, we should stay united. That is my closing ceremony. Thank you.
Thank you, Pak Ripat, Pak Firamala Anjaya, and go ahead to Pak Abdullah Zulkifli for answer and closing statement.
Yes, thank you, Pak Asep. So ASEAN has transformed when the organization was founded in Cold War era. At the time, ASEAN joined together to avoid the conflict between countries, and they can focus on what happened in the domestic. So with that situation, they can focus their energy to stabilize the region and avoid it to make a conflict with other country. And when the Cold War is over, then ASEAN embraces become bigger with Laos, Vietnam, Cambodia, and Myanmar. And now the change in this time of Indo-Pacific rivalry in the region, ASEAN have a new challenge again to expand the regional security architecture through plus cooperation. Like we have now ASEAN Outlook on Indo-Pacific, that it is a means to be a bridging between big powers, and it is different with Indo-Pacific from VOIP, because this ASEAN Outlook Indo-Pacific want to make trust in the region. So we in ASEAN, the challenges now not just intra-ASEAN but extra-ASEAN. That's why the big power like US, China, ASEAN need to engage to promote the peace and stability. And Indonesia in the position of very strategic. We have 3 sea lanes of communication, so we are very important for us to keep to manage the conflict, so not have spillover to area in the region. Thank you.
Thank you, Pak Abdullah. Again, this is the end of our session. Thank you very much. A big thank you for Professor Donald Rothberg in Canberra, Dr. John Bradford in Singapore, Pak Abdullah Zulkifli in Jakarta, and Firamala Anjaya in Jakarta too. I believe this is the fantastic and productive workshop for us, and I would like to thanks to all panelists for participation, and also on behalf of the organizer of the workshop, CSEAS, I appreciate distinguished guests from several embassies, representative in ASEAN, from universities, academician, research center in Indonesia, also the media person. Thank you very much for coming to the event. Good luck, stay stay in health, stay healthy during the pandemics, and again, goodbye. See you again in other CSEAS event. Thank you very much indeed. Bye-bye.
Thank you. Thank you.